Ladies and gentlemen, jokes aside, today's guest, Sean Murray. I'm actually super excited to pick your brain.
Yeah.
And I should let everyone know, I don't know you. This is our first time meeting. First Wednesday.
Yeah.
And I've done a few of these podcasts when my first time meeting somebody is on the show. And it's always really fun because I get to I don't know. I have no choice but to, interview with pure curiosity and, learning and stuff like that. But I do know a little bit about you. So I'm going to try to do a little bit of an introduction. But
Okay.
you're a father.
I'm a father, yes.
I learned that you're a marathon runner too.
Marathon runner, yeah.
Marathon runner. You're also a district attorney.
District attorney.
And that's all I've got on my list.
Yeah.
But there's our introduction.
Those are the three main things.
In that order. Yes, priorities. Yeah. So no, where I want to start is I want to learn a little bit more of your background. I'm really excited to dive in to your professional world and just kind of learn about your approach to that. But before we do, I'd love to know how you got there. Like walk me through, kind of your career trajectory.
Yeah.
To becoming the district attorney.
So in college, I studied philosophy, much to my parents' chagrin. They wanted me to be a doctor. And I tried the pre-med thing and I was like, I don't really love this living in the library, studying organic chemistry for crazy hours. But I fell in love with philosophy and I was going to the University of Virginia, got my degree in philosophy, minored in biology, and I wasn't really sure what I was going to do after that. So I decided to move to Colorado and be a ski bum in Breckenridge. I worked at Fatty's Pizzeria, bussing tables and hosting, and I sold lift tickets at Beaver Run. And I was just like a snowboard bum with my buddies. And I thought about it. I was like, I think I want to be a lawyer. So I took the LSAT, ended up going back to the University of Virginia for law school. And I wasn't really sure what type of law I wanted to practice, but eventually I settled on criminal defense. I had a weird experience as a kid where our PE teacher was filming us changing for swimming and then publishing it online. And he got arrested. Just ended up, I think he was sentenced like 20 years in prison. And nobody really sat me down and explained how sinister it was, what he was doing. And so I had this takeaway of like, oh, he was a nice guy. I feel like 20 years is too much. They should have treated him. I didn't really understand the extent of the harm. And so I had this in my head at a young age that I wanted to be a defense attorney. And so in law school, I just worked as a public defender. So I worked in Tennessee and Nashville and then Charlottesville as a public defender. So representing people that couldn't afford an attorney. And that was sort of my passion for a long, long period of time. When I was still in law school at UVA, I went to a conference in Bethesda, Maryland, met the public defender from Colorado. They thought it was cool that I already lived here, lived in Breckenridge, and they offered me a job. And when you take a job as a public defender, you get placed. So you don't get to choose where you're going to end up. I got placed in the 6th, which is Durango, Cortez. It's also the 22nd. So Cortez, Dolores County, Archuleta, over at Pagosa, and San Juan up in Silverton. And I worked as a public defender for 2 years. I ended up losing that job for dating a probation officer. And she's now my wife. So it worked out. It worked out. Love won is how I like to say it.
Right.
Yeah. And then I worked as a prosecutor initially in Cortez, which was interesting because I was spending a lot of time driving. It was like 3 years driving every day to Cortez, which wore on me. And then when Christian Champagne, the last district attorney, won his election, he offered me a job. So I worked under Christian for about 7 years and started as a deputy DA. So basically rank and file, that's like your basic position, but I was doing felonies. And then became an appellate prosecutor. So I was doing appeals like paper law. And then became the assistant DA which is basically the number 2 prosecutor. And then Christian ended up leaving his second term about a year early, and Governor Polis interviewed 2 other people, and chose me to replace Christian. And then I won an election about, I think we didn't actually get to a primary. My opponent dropped out after caucus and assembly because he didn't get a whole lot of support during the caucus and assembly portion. And then also I think he thought the governor's appointment and some strong wording around that appointment sort of was the last nail in his political coffin there.
Specific to the appointment of you?
Yes.
Educate me on how that works. The appointment versus election.
Yeah.
Just educate me on how that works.
Sure. So when a district attorney resigns, it creates a vacancy. And so they don't have like an immediate election. What they do to finish that district attorney's term is the governor has authority to appoint a replacement. So he'll interview as many people as he can, solicit applications. And he actually, I think my understanding is Polis asked a number of people to apply because he didn't necessarily want to put his thumb on the scale of the election, choosing one of the two candidates.
Right.
But then ultimately, I guess something about my application persuaded him that I was the right choice, even though, initially it didn't seem like he wanted to be involved in playing politics like that.
And then, so that for layman's terms, or just how my understanding, it basically that appointment would be like interim.
Yeah.
Or is that a temporary thing? And the election is then when it becomes
Yeah.
a term.
Yeah.
More permanent.
So the term is 4 years. So if you get elected, you then serve a 4-year term.
Got it.
And in La Plata County and Archuleta County and San Juan County, we're limited to 2 terms. There are some DAs, some judicial districts that don't have term limits, some that have 3 or 4, and we just happen to have 2. So
Should we do a whole podcast on term limits?
next time.
Okay, yeah, next time. Fair enough. Yeah, we'll save it for when I have a congressman.
Yeah, when I'm asking for a 3rd term, I'll come back and
Deal. Yeah, and we'll really like talk about cool. And I'm curious, and actually too, just to help set the stage a little bit, can you describe to me the responsibilities and the job of a district attorney?
Sure. So we prosecute all criminal cases in the 6th judicial district. So like I said, that's all the way over in Pagosa up to Silverton, and then all of La Plata County as well. And so law enforcement will typically initiate a case if it's a misdemeanor case or a petty offense, and they want to file it into state court in lieu of, say, a municipal court. Then they will present the charging documents, or they will arrest the defendants, and then we will figure out charging for a misdemeanor. With felonies, if they arrest somebody or they issue a summons, what we will end up doing is exercising discretion as to what we think should be charged. And sometimes that's not a charge, right? So sometimes we can say, look, law enforcement, I understand why you did this, but at the same time, we don't think this case should go forward. We don't think there's probable cause. We don't think we can prove these charges or these allegations beyond a reasonable doubt to a jury. So it's sort of like a check on law enforcement in that sense, deciding what charges should go forward, and sometimes deciding cases shouldn't go forward. We also review all of law enforcement's affidavits to the courts, so that basically it's a way of us making sure that their requests for search warrants, requests for production of records, like from, say, Google or Facebook, any sort of social media, we will review that and make sure it's sort of up to legal muster. The Fourth Amendment is satisfied by what law enforcement is saying, and there is probable cause justifying the issue, and so the search warrant. So that way the courts don't have to be sort of in this advisory role for law enforcement. We can actually play that, and there's a statute that mandates that we do that for law enforcement, sort of be in that advisory role where we're showing them, this is sufficient, this isn't sufficient, why don't we work on this, why don't we add that, or take this out, and that way we're sort of helping them improve their work product, making sure that people's rights are protected, warrants aren't issued when they shouldn't, things like that.
Yeah, I was just going to ask about that because, and I don't know how to word the question. I was initially going to ask, like, who do you work for type of thing. But really what it sounds like is that there's almost a responsibility or an obligation from your office, you and your team, to make sure that the process happens according to process, I guess, for lack of a better term. Like, so it's not necessarily that, because one of the things I want to dive into is the difference between when you are a defender versus a prosecutor. But in this context right now, you're the prosecutor, but it sounds like almost that there's an approach or a guidelines to make sure that it's within the confines of the, what's the word I'm looking for? But basically just that, like you mentioned warrants, that they were legal, and that, what could be used as evidence and things like that. Am I understanding that properly? That a lot of your guidance is more of like making sure that whatever happens in that system is within the confines of the law?
Exactly. Yeah. So basically, making sure that whatever happens in a case, we have an obligation to the law. So when you're sworn into office, you raise your right hand and you swear to uphold the U.S. and the state constitution and all the laws of the state of Colorado. And so the idea behind that too would include, if law enforcement's wanting to do something and we think, well, I have to protect defendants' rights too. I have an obligation to advocate for victims' rights and protect their rights, make sure their voices are heard. But simultaneously, I'm everybody's district attorney. So my boss is the whole population of the judicial district.
Right.
And so I have to protect their rights. That's a part of my oath, is to make sure that we're not doing something, and law enforcement's not doing something that violates somebody's rights.
And obviously without ever talking specifics, like I never, this is the this is a safe space, but also people are going to hear. So I, preface it with that. But are there ever instances where that kind of comes to a head? Because I'm curious about like, I don't know, the conflicting priorities of all the parties that are involved in that, and you having to kind of be the guy that says this is within the law or this isn't, or they have these rights and they don't. Like, is that ever, or is that mostly understood with all the participants in the system?
I think it ebbs and flows. It depends on the situation and the case. So there's often times where law enforcement will be frustrated with our decision making and they don't agree with what we're doing. And to the best of our ability, we'll explain to them this is why we're doing what we're doing. Here's case law from appellate courts, the Colorado Supreme Court, the Colorado Court of Appeals. Here's what the law says. Here's what we're going to stay within. And sometimes they want us to, prosecute this case or, sign this search warrant. And the answer is no. We kind of have to be willing to draw a line in the sand to make sure that everyone's rights are protected. And then it happens too with defense attorneys and with victims. So like I was saying, we have an obligation to protect victims' rights. Part of our obligation is to consult with the victim. So if we're going to do a plea agreement with a defendant, we have to, if we're able to, communicate that to the victim. So make sure that the victim understands what the offer is, what the defendant's looking at, if it's going to be prison, probation, community corrections, or a fine, something like that. We have an obligation to explain all of that to a victim if the crime involves a victim. And oftentimes victims aren't happy, and that can be the full range. It can be victims that are upset that think that we're not being tough enough on the defendant. And then other times, sometimes victims think that we're being, too soft on the defendant, or we should dismiss the case. That happens a lot in domestic violence cases.
Big.
The victim has an emotional connection, or they love the defendant. They don't want the case to go forward, or they're afraid of the defendant, and they think that if we continue to prosecute the case, that will endanger them. So that's a tough kind of needle to thread, is figuring out what's the right play, especially in domestic violence cases, where a lot of the times the offender is blaming the victim for the case, for the potential incarceration. And so there's not always times where we agree with victims about how a case should resolve. Unfortunately, it happens a lot in domestic violence cases because of that emotional connection to the offender. But it happens in other cases too. And sometimes we'll have cases with dozens or hundreds of victims, and they don't all agree with each other on what should happen.
Right.
And it happens with defense attorneys too. So defense attorneys have an obligation to advocate for their clients zealously, and they'll do so. And sometimes they think we should give an offer or we should do a certain thing as the district attorney, and we don't always agree. Sometimes we do. Some defense attorneys are really good at persuading us to do a specific thing. Other defense attorneys, not as good, maybe a little more aggressive in negotiations, which tends not to be as effective. I think the sugar is a little better than vinegar.
It's not like in movies.
No, I don't know. Sometimes the threatening, accusatory negotiation is the least persuasive in my experience.
Right.
Yeah. And I wasn't like that when I was a defense attorney. I was more like, hey, prosecutor, here's what's wrong with your case. Here's what your victim wants. Here's what you should do. And I tried to maintain a kind of professional demeanor and cordial dynamic instead of being aggressive.
I want to know more too about how it works, and then especially your role in it. I had an attorney on a while back, specializes in like civil litigation and conflict dispute and employment law and stuff like that. And it was really interesting because he was explaining to me that, especially when things get to litigation, that a lot of times people have, I don't know if regret's the right word, but it's like, man, once it's into the system, it's going. Yeah. And then it's this beast of an experience for everybody. And
Yeah.
so he's shifted a lot now to where he's trying to do conflict resolution pre litigation,
Yeah.
because he's seen the toll that takes on people. Sure. Obviously in your world, it's criminal, not civil. But you mentioned something there that piqued some curiosity of mine as far as like wants of the victims, or, if there is a victim, which is a whole nother question there I'm going to ask about. But I'm just kind of curious about how you balance that and where your responsibility lies. Like in his case, it was one of those where he really tries to advise people to avoid litigation at all costs because he knows how taxing it is, like emotionally, financially, obviously the whole thing.
Right.
In a criminal world though, like once there's charges, right? Like if the victim, because you had just mentioned there's some kind of anecdotes about maybe situations where, I don't know, you have to kind of hear what the victim at least their perspective or their wants, whether you act on that or not. But I'm just kind of curious about like how that plays into the overall approach to it, or is it like once it's in the, once it's a what's the word for it, a criminal case, thank you, that it's into the system. I can anyway, you teach me about that.
Yeah, I think there's something to that. There's what the way we say it is prosecutors have sticky hands, meaning like once they get their hands on a case, it's hard to let it go. And so what we try to do is have a sort of open door policy at the DA's office. So anyone can come talk to me about a case that maybe they have reservations about. Let's say
Anyone meaning
anyone should public attorneys, any of the other prosecuting attorneys. So that way, we can staff any case where maybe there's a change in the evidence. Maybe the victim, we call it recanting. It means to basically change their story or change their description of the events. Again, that's common in domestic violence cases. Initially, when the police respond, they'll say he hit me, and then a few months later, they'll say I made it all up. And so, yes, I think it's definitely taxing on the parties, the lawyers on both sides. It's taxing potentially on the victim when we go to trial. And on the system too, because there's a lot of resources, money and time spent subpoenaing witnesses, having motions hearings, and we will see like floods of litigation in a criminal case, especially in a felony. Lots and lots of motions followed by the defense. People are expected to file. The prosecution is also called the people. Expected to file responses, which can be, time consuming. You have to research the law. You have to research the facts. And now that every officer has to wear a body-worn camera and activate it anytime they're interacting with a citizen.
Oh, I didn't know that.
There's,
Every statewide.
yeah, so it was after George Floyd's murder. The Colorado legislature passed a Senate bill requiring law enforcement, and it was sort of a staggered rollout in terms of when they had to comply. But all law enforcement agencies, for the most part, have to have body-worn cameras, and they have to activate them
every time they're interacting with
yeah.
Interesting.
And so it serves a good purpose. I forget. It enables the public to have more trust in the legitimacy of law enforcement, but it also protects law enforcement from false accusations. When somebody says, "Hey, this cop did this," and we have body-worn camera that shows otherwise. So it's good in the sense that it promotes trust from the public for the system and law enforcement, but it's created a kind of tremendous amount of work for the public defenders and the prosecutors and other defense attorneys in the system that are trying to figure out what actually happened.
What's real?
Yeah, 20 officers responded to a scene. That could mean watching 20 body-worn cameras, which could be several hours long, depending on how complex the investigation is.
Right.
So there's just been a tremendous sort of exponential growth in terms of the amount of time we spend watching these videos since that legislation passed.
Is that a good thing or a bad thing?
I think it's good for the public, but I think we need to develop some more sophistication in terms of record management systems and software so that we can digest that without spending days watching the body-worn cameras. And
Right.
that might include AI, but not letting AI not just trusting AI blindly.
Why not?
Yeah, I've seen enough sci-fi movies to
Yeah.
healthy fears there. But yeah, I think it is a good thing, but at the same time, it's not over. We need to continue to develop more sophisticated systems so attorneys can navigate those without sort of losing their minds.
Right.
Because the money isn't there to expand. The public defender's office, they get their money from the state legislature, state level, and the district attorney's primarily funded by the 3 counties.
Okay.
And so there's a bit of a disparity there in terms of resources.
So are you, and again, if I'm asking too intrusive of question, feel free, but
Yeah.
are you then, it seems to me like there would be some funding discrepancies there. And to clarify my understanding, district attorneys are funded by the district, the counties, the judiciary, which is District 6, right?
Right.
The public defenders are funded on a state level.
Right.
Does that ever present issues as far as,
Yeah.
because isn't it always, it's always either the district attorney's office against either a public defender or a private defender, right?
Yeah. So sometimes the one caveat there is that we have what's called alternate defense counsel, and that just means a public defender has a conflict, so they can't represent a defendant, and then a private attorney contracts with the state to represent somebody that's indigent or
Physically acting as a public defense, sadly. Yeah, sort of.
Yeah, exactly.
Is there the funding discrepancies there that I would assume?
Yeah,
Because it's the same, same caseload, right?
yes, and it's concerning. And it's in a lot of states, it's kind of the opposite problem. I think in Louisiana, historically, there's been a problem with public defender funding. And so what we've seen here in the sixth is that with La Plata County's budget deficit in this year, uh, basically direction to cut our budget 15%, which would have been somewhat catastrophic. I cut the budget 5% by agreeing to cut an attorney position and agreeing to cut a victim witness position. So somebody that's full time, making sure victims understand the process, making sure their rights are protected. And I did that because basically we're getting direction from La Plata County, which is great. Well, I think around 80% of our budget is coming from La Plata County. They're saying that we don't have the money. We need all of these departments to cut 15%. And in our budget presentation, they said, well, what if you've cut 5? What if we cut 10 more? And I said, well, what if I cut misdemeanor prosecution?
Right.
Because at a certain point, it's like, if we're not getting properly funded, we can't continue to provide the services that we need to provide. So there is a disparity, and it's concerning. There's been lots of ideas presented. I'm not sure what the solution is, but I will say there seems to be no political capital up in Denver for funding district attorney's offices. That we got some money for the assistant DA position, which, as I said, is the number 2. And so they initially said, okay, we'll pay 50% of that budget. We had this bill where we were wanting to get more money for the elected DA and for the assistant DA, and make sure that their salaries were tethered to what judges were making. And the idea behind that was we don't want DAs constantly leaving and becoming judges, and then we have this constant loss, a revolving door of DAs. You need to just lose all the institutional knowledge when that happens. So that passed, but then the very next year, the legislature did a salary survey and said, where can we save some money? Oh, let's take back 25% from those ADA salaries. So they fund all of the public defender's office, but even funding, 1-2 positions of the DA's office was just too much.
Right.
I had to find a way to cut back on that, which was frustrating. And I think it's also frustrating for the counties too, especially in rural Colorado, because they feel these budget deficits, and they get mandates in the same way that we get mandates from the legislature. They're being mandated to pay X amount, and they don't have as much money as a lot of the metropolitan districts.
Right.
But the majority of the DA salary is paid for by the state.
Yeah. Okay. Yeah. So I would imagine too, and correct me if I'm wrong here, but the workload is directly correlated with crime rates.
Yeah.
Right.
Yep.
What's that looking like recently and on the horizon? Like, if anybody would have a pulse on ebbs and flows, up or down or sideways, what's that kind of look like?
Yeah, so we have a data dashboard which is publicly available, and people can look at the metrics, look at how crime has gone up and down. What I will say is it's gone down. In the last 24 years or so, we've seen sort of a steady decline in crime in the 6th Judicial District. That said, so I will push back a little bit on the idea of direct correlation, in the sense that while we've seen less criminal cases, there isn't really an institutional inhibition against what I was talking about earlier, which is lots of motions. So pre-trial, lots and lots of paper. And so we've seen a sort of an explosion of that, which is a good thing in some ways, that defendants' rights are being protected zealously. But again, when you attach body-worn cameras to that analysis too, the amount of work on any given case has gone way up.
I want to know your perspective on that. I forget exactly your words, but essentially that there's pros and cons to, I'll call it this new thoroughness.
Yeah.
Or the new, yeah. Because on one hand, I think, well, I want to hear your perspective, because I'll just leave it at that. What's your perspective on the pros and cons of the essence of that? And I think you understand what I'm saying, like the paperwork of it,
I think it's good in that we're protecting people's rights, but at the same time, when there's no inhibition against just filing whatever you can think of, sometimes we see motions that really don't have much basis in law or fact, and so the judges are sort of quick to deny those motions, but it still requires a response from the prosecutor. So, the judges have that expectation that any time a motion is being filed by one side, the other side, whether it's civil or criminal, is going to file a responsive pleading, articulating, and they have to. I think the judges expect you to. If you don't, there's a risk the judge could say, okay, you confessed to the motion, so I'm going to grant the motion no matter what it said because you didn't file a response.
right?
Hopefully they don't do that. Hopefully they would say, hey, please file a response. Sort of warn you that they might grant the motion. And so, while it's good that we have zealous defense, I think sometimes people can get carried away. Defense attorneys can file motions that really don't have a basis in law or fact. And it feels sort of sort of cynical at that point. Well, you're just trying to drown the other side and flood them with paper rather than get at the truth of what happened.
Yeah.
Yeah.
I'm curious, and well, actually, I've got another question, but I'm gonna save it. I wanna know, because you have a background in, defense,
Yes.
and now I'm learning all these terms. Look at me. It sounds like I know it. I'm a little bit, yeah. Um, I've even been dropping words like civil, criminal. I'm doing good, but, you got a background in defense. Now, obviously, you're on the prosecuting side. I wanna hear about that. One is the transition from one to the other, and then and what that's been like. And then secondly, I wanna hear how you approach it differently, if at all, being on the two different sides as far as defense and prosecution.
Yeah. Well, the transition initially was pretty difficult, because like I'd said, when I was in law school, it was sort of my passion to represent defendants, especially poor defendants. And I remember when I first was sitting in the courtroom in Cortez, and they brought the defendants that were in custody, so in the jail, they brought them into the courtroom, and that had typically been like my time to go and help, my time to go and advise. And I just remember sitting there and kind of feeling like this is going to be hard, right? This is going to be a difficult transition because so much of my empathy was directed at people that were caught up in the system. And now my empathy was sort of had to be broadened to the community as a whole and to victims, and still for defendants too, but a little bit, uh, yeah, a broader kind of empathy, instead of just, this is the team I'm fighting for. Um, and so that was challenging at first. And I think it's in some ways still challenging. It's been, um, 13 years now since I've been a prosecutor, and I still struggle sometimes. I still sometimes, whether I'm testifying in the legislature, arguing in court, arguing to a jury, I still find myself sort of questioning myself sometimes, like, wait, what am I doing? I remember when I was a juvenile public defender and I would have argued the opposite of what I'm arguing now. And in some ways, I think that's a strength. It's something that the governor mentioned when he appointed me. He was like, Mr. Murray can see both sides. And that's true because he's been on both sides. And so I think it's a strength, and it also prevents me from becoming one of those prosecutors that's a little bit too tough,
Right, like a heartless.
the scorched earth. Like, we're gonna get them, we're gonna send everybody to prison. Like, how we get to mass incarceration from some judicial districts, just believing that anyone that does the crime needs to do the time. And I think we have kind of a broader perspective with being willing to, create incentives for people to not have a conviction. Like, we have what's called diversion, where somebody's case gets dismissed and they engage in programming, whether that's alcohol and substance abuse programming or mental health treatments. Just trying to meet people where they're at and getting at the root causes of crime rather than just sort of cracking the whip all the time.
Right.
Punishment, 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 which is sometimes still appropriate. The crime's bad enough, or the defendant has a bad enough criminal history. We still think that incarcerating those kinds of individuals makes sense. But try to have a broader menu of options for people that maybe just made a mistake one time because they, had mental issues, substance abuse issues, or they were going through something difficult and they made a bad decision. So we try to understand that context in which the offense occurred rather than just hammering people. Yeah.
Tell me more about that, because I'm sensing from you that, like, that empathy stuff is sincere.
Yeah.
Like, and I can see. I'm too nice. Like, it's one of my. I'm dead serious. Like, I'm too much of a yes man. I'm way too, like, I relate to you in that sense. Like, if I were in your seat, I could see myself feeling those conflicting, like, because from a certain lens, you kind of go from being the good guy to the bad guy, and but I'm way overgeneralizing, obviously, but in certain contexts, I could totally see how it would feel like that, and I'm curious about, like, walk me through how empathy and the human element can still live in, the district attorney's office. Like, how do you balance those, the obligations, the realities of the job, the fact that you have to uphold the law and, all these realities with it, and then the human element and empathy and complexity. Walk me through when those converge.
Yeah. I think I've seen prosecutors before in different states and different judicial districts, with that sort of scorched earth philosophy where it's just, it's almost, for me, a little bit scary when you have people like that because it feels like they're suppressing empathy for defendants. And maybe some victims and maybe sometimes community members want that. They think that's like a good archetype of a prosecutor. And I just don't see it that way. I think that there's something lost when you just come in and try to hammer every nail. Everything's a nail when you're a hammer. And so one of the things that really opened my eyes up to a more empathic approach to criminal justice was problem-solving courts, which is essentially when there's kind of a treatment team that's led by the judge. And so for the longest time, we had what was called wellness court in Durango, which is essentially drug court. They have veterans courts in certain judicial districts, like in Colorado Springs, and they have behavioral health courts, so they're helping people with severe mental health problems. And everyone sort of sits down in a staffing and talks about like what's driving this person to commit crimes, and what do we need to do to incentivize, to use the carrot, so to speak, to prevent them from reoffending or to become more functional, whether that's better transportation, better social services, housing, the treatment that they need to address any issues they have, familial dysfunction. That sort of taught me to again look at the root causes of crime, look at what's actually causing this person.
The why behind the why.
Yeah, and
Yeah.
then try to change it. Right? If you want to reduce crime, if you really want to make a community safer, it's about more than just locking people up. It's about helping those people not reoffend and get on a better track.
Does that impact though the metric of success? And that's a sincere question. Like, yeah, because I don't know. Like, if are you measured on convictions as success, or successfully tried cases, or whatever? And
Yeah.
does that nuance impact like how? Because so much of the stuff you just talked about there is really hard to measure
Sure.
and really hard to put into action. Like long term initiatives and big change and things like that. Like, does that change? I guess first of all, how are you measured by success, and then secondly, does that change it?
So again, we have a data dashboard. People can go online and see the rates of conviction, the number of cases that result in dismissal, that result in a plea agreement, that are a conviction at trial or acquittal at trial. But for me, as the leader of the prosecuting attorneys, I try not to use that because I think it creates perverse incentives. So sometimes people will become more like that type of prosecutor I was talking about, where they're just trying to get people convicted. They're not listening to the defense attorney. They're not listening to the victim. They're trying to win, which is maybe the wrong lens to use when coming at criminal justice. And so, yes, we can look at that. And I've been asked that by some of the county commissioners in budget proposals, like, what's your conviction rate? And I'm like, well, I'll print some stuff off from the data dashboard. But for me, that's not a marching order I want to give to prosecutors. I want them to be courageous in litigation, to be brave and bold when it comes to doing trials or doing appeals. But fundamentally to do the right thing. That's sort of the guiding principle that overarches everything else is this the right thing to do?
So when you're saying, unpack that for me.
Yeah.
Be courageous, be bold, and do the right thing.
Yeah.
How do those walk me through that?
So sometimes doing the right thing, being bold and courageous might mean dismissing the case. It might mean you've got a great case and the police department really wants you to go to trial. The victim wants you to go to trial. The community wants you to go to trial. And you look at it and you think, the law doesn't apply to this situation. This defendant's not guilty. So you're dealing with all this pressure to produce an outcome. But at the end of the day, if the law doesn't forbid that conduct, then your obligation is to dismiss the case. Right? That's the right thing, no matter the pressure. And prosecutors sometimes refer to this as fulfilling our oath without fear or favor. So we don't make decisions based in fear or out of some hope of gaining favor. We're just there to enforce the law and to do the right thing. And oftentimes the right thing can mean dismissal. Sometimes the right thing can mean prosecuting a case even though a victim wants the case dismissed. Like, again, the example of the domestic violence cases where we're very confident that the defendant committed the crime, but the victim doesn't want the case prosecuted. The community is not really paying attention to the case. Why don't I just let it go? One less case on my plate. That's not the right thing. That's not the right thing to do in that situation.
Are there ever times when, trying to think how to word this, when the law prevents the right thing from happening?
Yeah, so I think that can be a situation. Sometimes we don't agree with the law, and so what that turns into is, and this is happening right now with what we call competency. So sometimes defendants are not competent to stand trial, meaning they don't understand the proceedings. They don't know what my job is. They don't know what their attorney's job is. They don't understand what the judge is doing or what the jury's doing, or they can't assist in their defense. They don't know how to help their defense attorney present their defense. They don't have that mental understanding of what's happening or how to assist. And so what ends up happening, we pass some laws that mandate when people can't be restored to competency, meaning if they've been committed to the state hospital or they're still at the jail and they're getting mental health services, but the mental health care providers can't get them to that place where they understand or can assist their attorney, then the case has to get dismissed. So we've seen some sort of scary scenarios where people are getting their cases dismissed because they were in that situation for too long under the statute, and then they go and they reoffend a scary crime. And so in that situation, what happens is everyone starts to come up with new ideas for legislation. So there's this organization called the Colorado District Attorneys Council, and that's sort of our legislative liaison. And we meet and we talk about what legislation we want to propose, what legislation we want to be opposed to, or what legislation we want to be sort of neutral about. We don't have a strong position. And we've got the full spectrum of political ideologies in terms of the 23 judicial districts. So there's very conservative district attorneys, there's very liberal district.
Is the district attorney, is that a partisan position?
Yeah. Okay. So every district attorney in the state is either a Democrat or Republican. There's no unaffiliated district attorneys in the state of Colorado. Yes.
And it's a political seat. Yeah.
Yeah. And there hasn't been a Republican that's run in this judicial district, I want to say I think really real quick, in about 15 years now. Interesting. For whatever reason, no Republican has thrown their hat in. So
Yeah. It's fascinating. Yeah, because I'm just curious about like, I can imagine that there are situations in your seat where I don't know if conflicting priorities is maybe too strong of a word, but where there's like this, we got to do what's right, we got to do what's right, and we've got to though uphold the law and be by the book.
Yeah.
And all of that. And I would imagine that it's never as clean as people think it is.
Right. There's a lot of difficult decisions. There's a lot of gray, a lot of nuance, and almost every day a difficult thing to do to figure out what the right thing is. And oftentimes I put my faith in the standards. So what does the law say is the right thing to do here? So if something gets really confusing, there's usually some sort of compass that the law is giving you, whether it's from judges making cases, so they interpret statutes, or the legislature making statutes like I was talking about.
And then that becomes the standard.
Yeah.
Yeah.
But oftentimes, so part of what happens with litigation, so some of those motions that we were talking about is constitutional challenges to statutes. So sometimes we'll bring a crime, we'll say this person violated this statute, and the defense will say, well, that statute's unconstitutional for this reason or that reason. It's void for vagueness, meaning nobody can understand what the statute's even saying you can't do. So my client certainly didn't understand what he did was a crime. And so what can happen in those cases is if the prosecution gets a conviction at trial, then the appellate courts will weigh in. And the appellate courts oftentimes publish their decisions. So they make law by saying, yes, this statute is unconstitutional. We're going to strike that statute, either in whole or in part. Or sometimes they'll say, no, that statute's not unconstitutional. And so that also develops law as well, is sort of the courts interpreting and deciding how legislation does or doesn't meet constitutional muster.
And that's got to be more like white collar type. Like I'm trying to think of an example where somebody wouldn't know that what they're doing was illegal, or am I just clueless? Am I just like out of it?
It happens sometimes where statutes are written with the best intentions, but courts that sort of see lots of the litigation briefing from both sides can find an example. So one thing that was invalidated a few years ago, there was part of the harassment statute, and specifically we're talking about telephone harassment. There's typically the issue there is First Amendment protection. So there's sort of a concern that if we legislate too much and we kind of go into that protected speech arena, then people are being basically punished for expressing themselves. And so the Colorado Supreme Court invalidated a provision that said with intent to harass. And they said, look, we know exceptions to First Amendment and protected speech include things like obscenity and true threat. So if you're actually credibly threatening somebody with harm to their person or property, or if you're saying something obscene, so something that's overly sexual, something that's prurient, that can also be an exception to protected speech. But they said, well, just this idea that you're intending to harass somebody, we can think of lots of examples of protected speech that are protected by the First Amendment, that would also meet the statutory.
Yeah.
Yeah. And so,
Plus, it's so subjective.
exactly. So you could just be making fun of somebody, um, and and that should be protected speech because you're not threatening them. You're not saying something obscene. And you could be prosecuted by some overly zealous prosecutor. And then the courts can come back and say, well, no, that's too far. So we're going to invalidate. So they basically just took a line item, took out that language from the statute. The rest of the statute still operates, but that part of the statute doesn't operate. So it can be sort of nuanced like that. Other times they can invalidate whole statutes where they think that it just wasn't properly done. And so oftentimes we'll see from judges on the Court of Appeals or the Supreme Court in Colorado, they'll kind of cue the legislature, hey, like maybe try this instead. Here's a thought. And they'll give ideas for the General Assembly to enact in their next session to make laws that actually pass constitutional muster.
Yeah, geez. It's funny because I would be the worst district attorney in the whole world because I am a spirit of the law guy, like not a letter of the law. You know what I mean?
Yeah, yeah.
And so I'm curious, like knowing that you're a great DA. So no, just a curiosity thing of has there ever been those situations where the spirit of the law isn't aligning with the letter of the law and that like dilemma, in that moment where you just the harassment thing, I can think of 1,000 examples where, you know, geez, did they or, but it was perceived as or, like there's all those gray area nuances that can happen in this world. Right. First, I want to know if that exists for you or not, just or if I'm, assuming that that's a possibility.
Mhm.
And then if and when it does, how do you handle that, with the professional hat on?
Yeah. So, I mean, I think at the end of the day, for me, it's the letter of the law is going to win.
Oh,
There's case law that talks about that. So the courts are like, you apply the plain language of the statute as it's written. And if it's not ambiguous, that's controlling. And so sometimes, it's tough because there's laws that are passed that maybe I don't agree with, like that I wouldn't have passed, I wouldn't have voted yes on. But again, coming back to that sort of foundational principle of my oath, it's incumbent upon me to follow the law.
yeah.
So it's like there could be a tension there between what I personally believe to be appropriate, and what's professionally obligated.
And what the job means.
Yeah.
Yeah.
So there's an interesting example recently. There was a case, I can't remember what judicial district it was out of, but it was individuals that were using AI to create fake nudes of other classmates and then like distributing it around the school. And this was before the legislature had had an opportunity to sort of catch up to that behavior.
Yeah.
And so there was a prosecution that basically said, look, this crime, this sexual exploitation of children. Because obviously these kids are pretty traumatized. Their parents are pretty upset that these fake nudes are circulating around the school.
Yeah.
And the Supreme Court of Colorado said, yeah, we get it, but this statute doesn't apply. The statute applies to real pictures, not to pictures that have been.
You see, that's the opposite of where I was getting at of like the spirit of the law is worse than the letter of.
Sometimes, yeah, yeah. And so the legislature, we've now passed a law protecting against that kind of behavior too.
Is that so? That's got to be so frustrating though when like the law has to come secondary, like in hindsight of a crime.
Yep. And they said that, I think in the opinion, the Supreme Court said, we recognize how crushing this opinion may be for the victims. And that's not lost on us, but our obligation here is to follow the law. And this is the only conclusion that the law mandates.
Because they can't, and you have that committee that either helps make new laws or says you're against new laws or neutral or whatever, like you were kind of explaining.
Yeah, yeah.
But gosh, the world has to evolve so much more quickly than the law.
Yeah.
Is that generally speaking almost always the case that a law gets developed after a new crime?
I think it's common and it's going to become,
And I guess it's not a crime at the time.
yeah. And it's common and it's becoming more common now that we have this sort of technological, expansion.
Yeah.
So we're going to be playing catch up a lot. And sometimes prosecutors are going to feel something is ethically and morally wrong. But maybe the statute doesn't include that behavior.
Golly.
That's a tough one, where we know something is wrong, but the statute just doesn't really apply.
Right. Yeah, you took a whole new spin on that because I was thinking more of like in the context of you knew something, I mean, I'm like I said, I'm too nice of guy. I have too much of a yes man. Always give people way too much of the benefit of the doubt, and you know, you know that saying like "fool me once, shame on you; fool me twice, shame on me," or whatever. I give you 100 tries. Like shame on it. Like okay, maybe I should have realized a pattern here.
Yeah.
But I was thinking more of it in that context of like, there's got to be those examples where there's a good person that was at the wrong place at the wrong time or whatever. And then the spirit of the law and the letter of the law. I had never even considered the opposite of that of like people doing harm, but the letter of the law
Right.
not being there yet. Yeah, that's got to be both of those scenarios have got to be frustrating for you to navigate.
Yeah, absolutely. And so that's one of the things that's nice to be on that committee, the CDAC, the District Attorney's Council, is because we're constantly giving feedback on what we're seeing on the ground level and advising what we think should be changed about the law. And so it's nice to be able to sort of have that body and hear about what's going on in the Capitol, but also make proposals for what should change with the law. Because yes, we do find ourselves frustrated in both scenarios.
Yeah, yeah.
Yeah.
From your perspective, does the system work as it is right now from your perspective?
In a lot of ways, I think it kind of, it's not perfect and it's never going to be perfect, but we have an obligation to make it as best we can and to look at what issues are there, to diagnose them and treat them and make them better. So one example now is we were talking about the body worn cameras and the difficulty of the attorneys watching all of those. Another dynamic that's become difficult is making sure that every body worn camera footage ends up with a defense attorney, because sometimes law enforcement officers can do so many different things over the life of the criminal investigation, and they can activate their body-worn camera several times. And sometimes that body-worn camera doesn't get into the prosecution's hands and doesn't get into the defense's hands. And so right now, there's an e-discovery task force where basically the District Attorney's Council and the Public Defender's Office are working collaboratively to try to figure out solutions to make sure that law enforcement agencies aren't losing discovery. So it's incumbent upon the prosecution to make sure that all the discovery, all of the materials, whether it's video footage, police reports, witness statements, whatever you can think of that would be tangible evidence in a case, that ends up in the possession of the defense attorney. And so there's a constant struggle there of making sure that, because of the 11 law enforcement agencies that I work with in this judicial district, they often use different record management systems, right? So I'm studying like different software, a different flow of evidence. And then you also have human error in and in the chain of custody, you see people making mistakes. Sometimes an officer doesn't tether the body worn camera to the incident number, so we don't know that it exists. And so that's a major area that we need to be working to improve the system, to making sure it's fair for every defendant. So a defendant doesn't get convicted when there's just some sort of piece of evidence out there that would have showed they were innocent.
Right, right.
You don't want that.
Do you have any idea, like, and this is a curiosity, I'm not looking for, hard numbers unless you have them, but like statistically, as far as, people that get convicted or serve jail time or prison sentences or whatever, any idea like how often a wrongful conviction happens, like percentage wise?
I don't know the exact percentage. There are innocence projects throughout the country that basically work with people that are asserting that they're actually innocent. And we should have some data through the state court administrator's office. So basically, they keep data pertaining to convictions. And there's a statute that mandates that when somebody does establish actual innocence and they were convicted, then we owe them compensation based on the amount of time that they were incarcerated. So there's been situations where I've agreed that somebody was wrongfully incarcerated, and asked the court to set aside their conviction.
Has that even been when you were the prosecutor?
Yes.
Interesting.
And there's been times where somebody, changed their life, like got their face tattoos removed, want to join the Navy, their crimes were committed when they were 18 or 19, and I've just agreed to maybe turn a felony conviction into a misdemeanor based on them sort of turning their life around.
Right.
More evidence on how to, use a carrot to incentivize people to change their lives,
Right.
not to continue down this criminal path.
Do you believe that that's I don't know, because I don't want to put you in a spot or like ask you a question that might get you in trouble. I was going to say, if you could change anything, what would you change? But
Yeah.
if, because you've brought up that theme a few times as far as like the why behind the why, or, hanging the carrot, so to speak. Like, do you feel like a world with more nuance would be beneficial in the criminal justice world? Or do you feel like the letter of the law, as we discussed, is the most accurate way to go about things? Like, what,
Yeah.
share your perspective on that.
I mean, I think there's space for both of those things to kind of coexist. I think the letter of the law is something that we have to follow, but I think it's important for, especially for prosecutors and judges too, to exercise discretion in a way that's evidence based. So looking at, national data or statewide data, what's effective. If we're going to purport to make the world a better place, to make the community safer, let's figure out what's actually making a difference. So like you were saying, in terms of the rates of wrongful convictions, let's look at the rates of people that are coming back into the system or getting rearrested within 2 years. We call that recidivism. There's different ways of measuring it, but I think the best, there's some good evidence nationally that those problem-solving courts like veterans courts, drug courts, actually reduce recidivism compared to standard probation. So we know
Define that for me. Sorry. Yeah. Reduce repeat offending.
exactly, yeah. So they look, basically what they'll do is, and this is usually done by something like the state court administrator because they have data from the courts. They'll look when somebody's been sentenced to, say, prison or halfway house or probation. Did they get rearrested within 2 years? Did they get rearrested within 5 years? And then looking to see whether or not the person, turned that corner or continued to living a criminal lifestyle. And so looking at what's effective. So I think it's critical, swearing at following the letter of the law. That's bedrock. But at the same time, it's important for people to be nuanced and to think about, how do I make a difference within the letter of the law?
Right.
Where I do have discretion, where it's not, this decision making isn't outside of the law. It's just different from the hammer to the nail.
And by that you mean, by decision making, you mean in terms of like what charges you're bringing or what the judgment is, or
What offer? Like, am I going to offer a felony? Am I going to offer prison? Should I offer probation? How dangerous is this person? How bad was the crime? Did they murder somebody? Okay, we're probably not talking about probation then. We're not going to talk about a halfway house. If they murdered somebody that's first degree or second degree, we're talking about a lengthy prison sentence. Or if it's a sex assault or they sexually assaulted a child, we're going to be generally talking about a lengthy prison sentence.
right.
Yeah.
Because, and again, forgive my ignorance, but does your office actually investigate as well, or are you guys, you're given information and they decided what to do with it?
So we do have investigators, but their function isn't typically starting in a criminal investigation. Typically, their function is supplemental investigations, like we're preparing witnesses or exhibits for trial, figuring out information that the prosecutor needs to get the conviction beyond a reasonable doubt. Yeah, and also issuing subpoenas, finding witnesses, things like that. It's a little bit different than what law enforcement does with their investigations, where they're building the case. And we want the tracks to be well built before the train leaves the station.
Right.
We want a good investigation. So sometimes when it comes to our discretion with charging, what am I going to charge here? We'll send it back to law enforcement and say, look, we need you to finish this investigation. You didn't get the bank right.
We need is more A, B, and C.
You didn't get a subpoena on the Instagram profile. I need the messages from the Snapchat, which is a problem because Snapchat doesn't save its messages. Yeah. So oftentimes
Can they even not be like subpoenaed, like archived?
they can, but there's a lot of snaps basically just aren't saved. So it's basically just gone forever.
Interesting.
Yeah.
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 Yeah. And I gotta imagine, gosh, like chasing this moving target with technology evolving and, you know, all these things. My wife and I, we like to watch like criminal shows, and I know that it's nowhere near reality, but I'm always like, man, you could not commit a crime nowadays with all the, you would know where I am every minute of every day, all the security like there's no, on one hand, it seems like with the evolution of technology, it's harder to get away with stuff.
Sure.
But on the other hand, there's also like ways I think to use it.
Yeah. I mean, yeah, absolutely. I think the internet and all 23 DAs were in support of legislation to sort of regulate social media companies. And unfortunately, the governor vetoed it because he thought it was a restriction on their First Amendment speech, which we respectfully disagreed with, because that's where, following Jonathan Haidt's example in the anxious generation and some of his works.
I'm reading about rights.
It's good. And I think even following him on social media now, he talks about how there's these new trends that apply, that he didn't know about when he wrote it several years ago. I can't remember exactly what it is, but it's like look maxing that young males are engaging in, where they want to look a certain way. Yeah, and it's just it's kind of scary. Not only in terms of that sort of stuff, like causing depression and anxiety.
We could do a whole podcast on that.
Yeah, but also predators, right? Predators using Roblox, using Instagram, using Snapchat to find prey, young kids that are susceptible to that online. So it's like he says, we're overprotecting kids in the real world and underprotecting them in the virtual world.
Yeah, isn't that the truth?
Yeah,
Yeah, and then from the law side of it, the virtual world is evolving so much more quickly
yeah,
than the real world. Yeah, which has got introduced endless complexities. Yeah, I can't imagine having to navigate all that. So I'm curious too, because you mentioned about we were talking a little bit about wrongful convictions, and that there's even been some cases where you've learned. Are there ever situations where, and again, I apologize for my layman's terms, but law enforcement arrests somebody, they lay the tracks, so to speak. Train leaves the station and it ends up on your desk, and now your job is to decide what to charge them with, right?
yeah.
And so the initial charges from law enforcement aren't always the charges that then end up, you know, being the final charge. As you guys decide that.
Really common that we'll change it because we don't agree with what law enforcement's take on the charge was.
Because there's more information.
Or we just, we have a different reading of the statutes, we have a different reading of the facts, and we think, well, this statute applies better than the statute that they thought applied. And so the statute that they arrest for often will impact the level of offense will impact how the judge sets the bail, sets the conditions of the bond. But yeah, we're not beholden to following, what law enforcement says we should charge.
Right.
Yeah.
Because what I was going to ask is, are there ever been situations where, like, you've engaged, like you've started, you're trying a case or whatever, and new information arises that changes the perspective, or and what do you do there? Like, do you change, or is it now it's going?
It depends. So sometimes, and again, in domestic violence cases, we see recantation a lot, where the victim will take the stand and say it didn't happen. And then we'll bring in an expert to say, this is why victims recant. They love the offender. They don't want the offender to be in trouble. They're afraid of the offender if he gets convicted. So in that situation, we don't always say, well, we're not going to prosecute the case because we expect them to recant. We expect that change in narrative. But in other instances, where I think one we were talking about, a victim recanted and changed the description of whether or not sexual contact was consensual. And so certainly once we heard under oath testimony, well, no, it was consensual, then it was sort of like, well, this isn't a domestic violence case. There isn't an expert that's going to come in and explain that this recantation is for these reasons. That gave us our own reasonable doubts. And if we have our own reasonable doubts, then we don't want to get up in front of the jury and say there are no reasonable doubts here.
Right.
So that's,
Because you have to have no and that's kind of what I'm getting at is like, again, and thank goodness, and hopefully it stays this way, that my perspective of the system is, fiction based, TV shows and movies and stuff. But, there's always this like kind of perception that it's like, you're the prosecutor, you're the defendant, and it's like, I'm going to die on that hill. And, like we're going to, we're going to, through hell or high water, we're going to prosecute this.
yeah.
It sounds like there's way more. Well, I think you worded it well. Like, if we have a doubt,
Yeah.
then in good conscience or even by the law, we can't,
Yeah.
we can't continue to pursue.
Or if we think there's no reasonable likelihood of conviction, that's that's a legal standard that we would apply and say, I believe in this case, but I don't believe that I can prove it.
Yeah. See, again, you're switching the context on me. That's gotta be impossibly frustrating.
It can be hard. Yeah.
Like, where you in your gut, the info you have,
Yeah.
but there will be doubt. Like, there's not enough or whatever.
Or the judge suppressed some piece of evidence and this person is guilty, but you also know without that evidence, you can't prove the case.
Walk me through that. Like, how, because without going into way too much of a rabbit hole, I was going to ask you about it. Like, if are there people that are above the law, like, and because we've got all the Epstein files, on our feeds and everybody's seeing all that. And gosh, what a can of worms that is.
Right.
And it's like, geez, who's telling them what to redact and whatnot, and all that stuff. Obviously,
And there's victim information that should have been redacted, photographs that should have been redacted that
there was a
did.
yeah.
That's something that we have an obligation to do too, even at the state and local level, is to make sure that victims' information isn't being disseminated. It's not great when that happens. So,
Does it exist that people are above the law ever?
I mean, so we know that like there's certain rulings like that the president of the United States has immunity in his official capacity. So for actions that he does in that capacity, he's immune. Um, and then the answer should be no. So if especially at the state and local level, nobody should be above the law. So I have to ask myself that, like, I've sort of set aside who this person is. Is this person a law enforcement partner that happened to commit a crime? Is this person, somebody that's so close to me that my office shouldn't prosecute the case? And then what I have to do in that situation is have somebody from Cortez or from Alamosa come and prosecute the case, because it's not fair to ever get, this person's above the law because they know Sean Burry. Like, that's not fair. That's not a fair system.
So I don't have now that I've been on a podcast with you,
I don't have any get out free cards in that pocket.
okay. Thanks for the reminder. I was thinking I had a free card after this, but
No, unfortunately, no.
I jokes aside though, like, I don't know, and again, not like looking for instances or anything like that, more of a perspective piece, but I don't know, where a judge says that, a piece of evidence is, I forget the word you use for it.
Pressed isn't fresh. Sure, you would hear about it. Yeah.
That's gotta be, I mean, it's gotta be frustrating.
Yeah. We can appeal. It's called an interlocutory appeal. It means that when that happens, we can take the issue to the Supreme Court of Colorado and say the judge was wrong. We should reverse and let us admit the evidence. And that's happened a few times since I've been working at the DA's office, where we were confident that the judge was wrong, like suppressing a confession. That's a common one where the defense says this was a violation of Miranda, or this was an involuntary confession. The police were so coercive they overbore the free will of the defendant, and the statements are therefore the product of an overborne will and have to be suppressed. And we said, well, we think the judge is wrong, and we've had some success with getting the Supreme Court to kind of give us that evidence back, and then we can go forward on the case. But in many instances, it's sort of fatal to the case, where it's like, well, we can prove this because the defendant confessed, but without the confession, we don't have enough evidence to sustain a conviction.
Right.
So that can be fatal to the case. Yeah.
And I would imagine there's times when it's suppressed, rightfully.
Sure.
And then when it's not, or wrongfully, and whether it's even like malicious or not, I guess is irrelevant. But it is good to know that there's paths that you can take when it shouldn't be suppressed.
Yeah, absolutely. Yeah.
Yeah.
There's recourse. Yeah, for sure. And sometimes we should catch that too. So that's another thing that we're deciding when we're prosecuting a case and doing the filing of charges, figuring out what should we charge here, or even getting ready for a motions hearing. We can look and see, and it's sort of incumbent upon us, and again, our oaths, to figure out, is this a constitutional violation? Like, did the police officer violate this person's rights?
Right.
And if so, we have to take a stand and, again, draw that line in the sand for law enforcement and say, I'm not prosecuting this because this was a violation of their Fourth Amendment rights. You didn't have enough to seize this vehicle and say, we're going to wait for the drug dog. Well, you'd already told them that you were done explaining the reason that you gave them this ticket, this warning. So there's U.S. Supreme Court precedent that says you can't just wait for the dog at that point. You can't extend the scope of that stop. And so that's a difficult conversation, because law enforcement doesn't always appreciate that call where we're like, yeah, we're going to dismiss. They're like, but they're a drug distributor. And it's like, understood, but the Constitution is a Constitution.
Letter of the law.
Exactly.
Right. Yeah. I'm glad I'm not a DA. If you could change one thing, what would it be?
If I could change one thing, what would it be?
With the system, with your job, your office, the system.
Yeah, I mean, I think it would be more collaboration between the sides. And I understand the system's adversarial between the defense and the prosecution, but having been on both sides, I think everybody would benefit from a greater shared space for truth, greater negotiations, like you were saying about your civil attorney that sort of understood the impact that litigation has on the parties. More of that, more empathy and more appreciation of nuance, and less of that kind of getting dug in like you see on TV, where it's, we're going to die on this hill. And I think it depends on who the legal, I'm forgetting the exact term, but who's giving the legal advice to the writers on those shows. Sometimes it's like so obvious that it's a prosecutor or that it's a defense attorney, like the way they kind of like shade the other side. Yeah. But yeah, I think it would empathy and collaboration between the sides instead of just this belief in the value of an endless war because I think it takes its toll on everybody.
Yeah. Well, and I mean, from an outsider looking in, it's like, well, duh, that would be great for all of us. Collaboration, because I think, well, at least for the public, like, for like, as the outsiders looking in, I think a perfect role for us would be a perfect system that arrives at truth.
Yeah.
Either innocent or not, and collaboration, because hopefully, and correct me if I'm wrong. Well, I maybe I am wrong. I would imagine, knowing that your metric of success, but potentially at other DA offices, the metric of success is conviction.
Sure.
Uh, Public defenders, their metric of success is non-prosecution. I don't know the term.
To a certain extent, I think sometimes they have broader goals like helping mitigate damage.
Yeah, yeah. Eh, but is there, like, what's the solution to that? Because if somehow you could take away this idea of like winning or losing,
Yeah.
you know what I mean, and just arriving at truth,
Yeah.
seems ideal to me. Obviously, uh, incredibly complex of how to get there. But any ideas on how to start down that path with more collaboration, more empathy?
I think it's a lot of it's like I was saying, problem solving courts, but not just having problem solving courts, having sort of trauma informed care, having people be more aware of, like we were talking about, what types of treatment work. Like this modality is going to cause a reduction of recidivism. So people are not going to come back with this population. And then using evidence based devices to figure out what's the right kind of treatment for an offender. Or is this person just so dangerous they need to be incarcerated?
Right.
If we're concerned about the future reoffending. Sometimes people's crimes are so bad we're less concerned about that, and we want to lock them away. Uh, so yeah, I think we would all benefit from appreciating nuance more, from being more evidence based, and not kind of having that philosophy of I'm gonna die on this hill. I'm so set in my ways. I've got this figured out. I'm gonna fight to the end. I think there's a time and a place for that, but it's few and far between in terms of the cases.
Do you get to influence it at all? Like, now that you're the DA, yeah. Well, do you, and for a long time, but do you get to inject that into, our little corner of the world?
Yeah, absolutely. I've been reading what's the name of the book? Extreme Accountability or Extreme.
Extreme ownership. Yes, on my desk right there. That's a great book. Yeah.
And I love the part about how like it's incumbent up. There's no bad teams. There's just bad leaders, and like it's critical to be able to communicate what your directives are to your middle managers and to your rank and file. And so I think it's critical for me to be able to share that message with the other prosecuting attorneys, with the support staff, with the victim witness staff, and with the defense counsel, with the judges too, to be able to use my voice and my influence to make the system better, and for us all to do a better job. So yeah.
Do you think that there's more, or do you think that where you're at offers the most opportunity for influencing that shift? Or because we talked about early on in our conversation, kind of like the the challenge of moving from, defense to prosecution, and wearing that other hat and things like that. I'm wondering if, from your perspective, that either side has maybe more ability to influence sort of
Yeah.
that that approach.
I think so. I mean, I felt that I've had more ability to influence change within the system from the prosecution side. Um, I enjoyed being a defense attorney, but in some ways, it's kind of like you're stuck with the case that you get, with the client that you get, and the offer that you get from the prosecution. Whereas the prosecutor can sort of shape justice and change the way that we get plea offers, change the types of sentences that we're arguing, change the tone that we're using in court. Like, how are we just saying all the worst things we can think of and itemize about the defendant? Are we, how are we interacting with victims? Are we sort of like, yeah, I hear you talking, but, you're just sort of chirping over there. And, I've got this,
Right.
adults are talking now. I think that sort of philosophy or that sort of treatment of victims is really harmful. And so I've tried to inculcate a culture of treating them with respect, hearing them, even if you don't agree with them, and explaining to them your decision making. So why you're doing what you're doing in this case in a way that um, ensures that they feel heard and that they feel respected, because the last thing we want to do is make them think that their voice doesn't matter.
Right.
And I make that point to the judges a lot, and I teach the prosecuting attorneys to make that point to the judges a lot, that it's easy to have empathy for the defendant because you have power over him and he's standing right there. But it's important for you to have conceptual empathy for the victim and for the community, which is a little bit harder to do. But you have to balance those things to really get at justice, I think. You can't just treat one side as the side that's worth caring about.
Right. Yeah. Is I'm sorry an admission of guilt?
I would think so, depending on the context, generally, yeah. So that happens a lot where people will do what call pretexts. So where somebody's saying, you know, this person hurt me all these years ago. A lot of times with law enforcement, they will say, okay, we're going to get you to text it and get him to try to admit that what he did, right? So we can get not only your statement, so it's not just a he said, she said, so they both said that it happened. So they'll be sitting there looking at the text messages and recording the responses and try to elicit from an offender, I'm so sorry that I did that to you. I was drinking a lot at the time. I had all these issues going on. That wasn't fair. I shouldn't have done that. They don't realize with that law enforcement is actually on the other end.
Right.
And it might not be a text. It might be a phone call, something along those lines. So that's not uncommon that law enforcement uses this sort of tactics to catch people confessing with crimes accidentally.
Yeah. It's I don't know. I was gonna say it's too bad, but because if there could be like some other ways to to acknowledge empathy, without an admission of guilt,
Right.
type of
So we do that in diversion. We don't make them admit to guilt. We don't use it against them. So one part of our programming is, okay, we're gonna dismiss your case, but you're gonna do these things. It's like, classes or apology letter, a victim offender conference where the harm party gets to hear from the defendant and vice versa. And we won't take those admissions and use them against them because we'll want to foster that sort of openness.
right.
Yeah.
Yeah. Yeah. Gosh, it's gotta be what a complex, like nuance filled world.
Yeah.
So let me check my timeline. You've been the DA for
Almost 2 years.
okay, 2 years.
I finished my predecessor's second term, and I got sworn into my first term as an elected official in January.
Got it. Yeah, cool. So plenty of lead time on the horizon, for you. What goals do you have? Like what are you kind of looking ahead? Let and we've established that conviction rate is not the metric of success. It's not. But 8 years from now, we look back and it was successful.
Yeah.
What made it successful?
I think, again, it's going to feel like hard to measure kind of things, like treating victims with respect and feeling like the victims that we had were heard, and didn't feel like we turned a blind eye on them. Pursuing excellence at trial and in appeals. And sometimes, yes, that does mean winning, so to speak. Even
Winning's not the end of the world.
our function is supposed to be truth and justice. It's not supposed to be just win, win, win. And so sometimes those things are overlapping now. So yes, at times it's good to win a trial. And then sometimes to learn from our mistakes too. Like, again, coming back to the extreme ownership book, like actually sitting down after an unsuccessful case or any trial really and saying, what could we have done better? What mistakes did we make? How can we work better as a team? And diagnosing and treating those things. So we're always trying to get better, never resting on our laurels and thinking, oh, we got this figured out. We're the best of the best. And just having that growth day in and day out. I think that's another, again, difficult to measure thing, but yeah. And I also think, treating everybody equally. So sometimes one of the things that we can use our data dashboard for, and we're working with some data scientists from outside institutes, is to see, are we arguing for more higher bail and lengthier sentences for Native Americans? Are we doing that for Hispanic people relative to white people? And making sure that we're not using implicit bias to treat different groups differently.
Yeah.
That guy looks like me, so I understand him. His crime isn't that bad. I could have made that mistake. Whereas somebody who doesn't look like me or has nothing in common with me, am I hammering that person? So trying to make the system more equitable, more fair for everybody. So yes, it's not like, somebody is above the law or somebody has some sort of privilege that they can apply to escape justice.
Right. Yeah. No, I love it. And what a great perspective to bring to it of like, well, equality and fairness and all of that. So yeah. Sean, thank you so much. It's been really fun to I've learned a ton sitting across from you, and it's cool to see. What I've really appreciated is your approach to it, and we've talked about it quite a bit, but the perspective from both sides, and then I love the idea of increased collaboration, injecting empathy and nuance and all of these great things into this rigid system, which is, I know, easier said than done for sure. Um, but it's refreshing for me to sit across and talk to you and hear that that's happening, and that we've got somebody that's starting to at least work down that path. It's encouraging. So I've got a gift for you. This is how I end my shows, but
Awesome.
this is one of our Inspired by Example shirts. Because it really is inspiring. You think about, like, until this conversation's, and like I said, thank goodness I haven't, I had to be in the system, but we could watch movies and stuff, and it seems like this whole thing. And then we talk to real human beings with empathy and nuance and discretion and all that stuff. So I want to thank you for it, for breaking that to the seat that you rated to, and for inspiring by example.
No, thanks for having me. This has been great. It's been awesome. Okay.
Thank you.
Yeah. Look forward to doing it again.
For sure.
Okay.